So once contracts have been exchanged for the sale of a property, and that's including their agreements for lease or agreements to surrender leases, the parties are usually going to consider that that's the end of any stress and uncertainty. That's the beginning of the process of organising the mechanics of completion of the transaction. Now, failure to complete by one or other party, of course, that's possible. It's not anything like as common as a party withdrawing before exchange of contracts. And withdrawal before exchange naturally doesn't give rise to remedies to either party. That's just an unfortunate fact of life. But it is that slightly less common situation, failure to complete, that we're going to be talking about. And that's a different matter. There are well-established remedies for that. And of course, they're codified in the two major sets of standard conditions, the standard commercial property conditions, the SCPC, and the standard conditions of sale, the SCS. And there's a developed body of case law surrounding the available remedies. Case of Hooper and Oates in 2013, which is to do with the date for assessment of damages. Now, that's an interesting point. So the Court of Appeal there had to decide upon what was the relevant date, and this was damages payable by a buyer who had failed to complete. And the situation there was that the sellers had tried to resell the property. They hadn't been able to find another buyer. Reluctantly, therefore, they moved back into the property and occupied it for their own purposes. Now, the Court of Appeal held that the date when damages should be assessed, the assessment of the market value of the property, was not the date for completion, the date of breach, but the date when the sellers brought to an end their reasonable attempts to resell the property and took it back for their own use. And by that time, because the market had declined, it was worth considerably less. So that increased the amount of damages payable. The breach date may well be the right date for assessment of damages, but only where there's an immediately available market for the sale of the asset, or if it's a seller in breach, for the purchase of an equivalent asset. It was hardly ever the case, the court considered, that there's a readily and immediately available market for the sale of or purchase of land, in the sense that the seller can go out into the market on the date of breach or the next day and find a purchaser who'd be willing and able to proceed at once.